The ATF has finally been cornered, forced to acknowledge a major defeat in court that could reshape how gun owners defend their rights. Imagine their shame. It's a rare moment where a powerful but corrupt federal agency like the ATF admits its overreach, so this is some exciting news. In this video, we'll talk about the ATF's forced letters to owners of forced reset triggers, the ongoing lawsuit against rare-breed triggers, the Supreme Court ruling that sparked a turning point, and why we, as staunch supporters of the Second Amendment, should remain vigilant despite these promising legal victories. For years, the ATF has drawn anger from all pro-Second A individuals due to their shifting interpretations of federal law as a method to impose new bans without congressional approval. The forced reset trigger issue is a perfect example. Originally, these triggers were considered legal devices that allow a semi-automatic firearm to reset the trigger more quickly, making rapid fire easier while still requiring a distinct pull for each shot. Then, practically overnight, the ATF decided these triggers were akin to illegal machine guns. Thousands of law-abiding folks who had purchased FRTs in good faith felt blindsided. This redefinition by an unelected body illustrates how the ATF can retroactively alter regulations and put decent Americans at risk of felony charges. When letters arrive in your mailbox telling you your once legal purchase could land you in federal prison, you start questioning how any of this aligns with the Constitution. Thankfully, the agency's aggressive approach drew the court's attention. Around the time the tension over FRTs was brewing, the Supreme Court delivered a major ruling on June 14, 2024, in the Garland v. Cargill case, widely known as the bump stock case. There, the justices concluded the ATF had no authority to expand the definition of a machine gun to include bump stocks. Congress alone writes our laws. The ATF is supposed to enforce them, not create them. That ruling was a welcome development for those of us who believe in limited government. It made clear that when an agency bypasses the legislative process, it violates the very structure set up to protect our freedoms. This Supreme Court decision emboldened further challenges to the ATF's stance on FRTs. By July 2024, Judge Reed O'Connor of the Northern District of Texas issued a pointed ruling condemning the agency's reclassification of forced reset triggers. O'Connor argued that the ATF's attempt to categorize them as machine guns went beyond the authority granted by Congress. He also reminded us that our nation was founded to prevent unaccountable power from being concentrated in any single arm of government. This principle is doubly crucial when it comes to the Second Amendment, because once government agencies can define or redefine firearms at their whim, the very real consequence is that ordinary citizens risk becoming criminals overnight. Not too long after O'Connor's ruling, the ATF had no choice but to send out a second series of letters to individuals who had previously been warned about potential legal trouble for owning an FRT. These new letters were supposed to correct the record and admit the possibility that the original warnings were misguided. Yet the language the agency used left owners uncertain. It referred to ongoing appeals and hinted that the ATF could shift its position again. It also failed to give a definitive answer on whether owners could be prosecuted in the future. That kind of vague messaging only adds to a climate of anxiety for anyone who wants to remain law-abiding but finds the rules constantly in flux. Meanwhile, the ATF's website added more confusion. They managed to post two versions of their notice, both intended to address the forced reset trigger matter, yet each carried slightly different information. The phrase, "may have received a warning," implies the ATF is non-committal about whether folks were genuinely threatened with prosecution. Rather than clarifying the situation, those conflicting drafts show a scattered approach that undermines public trust. This is typical of how the agency operates. Publish uncertain guidance, let gun owners scramble, then blame the public for not instantly knowing what's legally permissible. In the middle of this chaos, rare-breed triggers took center stage. If you haven't heard of them, they're known for manufacturing a popular version of the FRT. They've been saying all this time that their design did not produce fully automatic fire. When the ATF labeled the device illegal, Rarebreed continued selling it, maintaining that no law had genuinely changed. The Department of Justice then sued Rarebreed in the Eastern District of New York for fraud, asserting that the company disregarded the ATF's determination. Pro-2A advocates see this as an attempt to financially cripple rare breed through legal costs rather than engage in a fair legislative debate about whether forced reset triggers violate federal law. If the DOJ can drain a company's resources, it can effectively shut down production without needing to prove wrongdoing in a legislative context. Rare breed, however, is fighting back. They warn customers that the only legitimate place to buy their FRT is through their official website, ensuring that any purchase helps support their legal defense. Fake or unauthorized websites might offer cheaper knockoffs, but none of that money supports the battle against federal overreach. For many of us, this is not just about a trigger device, it's about resisting an attempt by the government to manipulate definitions and policies in ways that threaten the Second Amendment. Having a robust firearm accessories market means we have the freedom to choose how to equip ourselves. If the government succeeds in collapsing rare breed, it sets a precedent that any product the ATF dislikes can be chased out of existence through a similar lawsuit strategy. Real quick before we continue, if you're liking this video so far, please consider subscribing to our channel and clicking on the bell icon for more of these videos. We upload a new video every day, and every bit of engagement helps us continue doing what we do. Make sure every Pro-2A American is well informed of government overreach. So going back to the story, multiple organizations, including the National Association for Gun Rights and other Pro-2A groups, have spoken in support of rare breed's stance. The injunction that halted rare breed sales in New York is an attempt to curtail Second Amendment freedoms beyond what Congress ever intended. Some observers speculate that the ultimate fate of forced reset triggers, and perhaps similar firearm parts, will hinge on how appellate courts interpret the logic of Garland v. Cargill and O'Connor's subsequent rulings. If the higher courts rule consistently, the ATF may be compelled to step back from its reinterpretations, preventing arbitrary bans without new legislation. Not surprisingly, the ATF is keeping the door open for possible future enforcement. Even though they've been forced to acknowledge a court order that undercuts their stance on FRTs, they emphasize that appeals are pending. That's a reminder that while we celebrate these temporary legal victories, we cannot afford to be complacent. The ATF has shown it will exploit every legal loophole and keep testing the limits of its authority. This means more court cases, more potential for confusion, and more burdens on people who are simply exercising their right to own the tools they deem necessary to protect themselves. Judge O'Connor's opinion explicitly criticized what he called a rampant evasion of the democratic process, highlighting how agencies like the ATF circumvent the usual checks and balances. This resonates with millions of gun owners who ask why a bureaucratic institution can wield such power without direct accountability. Our Constitution is meant to safeguard rights by dividing authority among the three branches, ensuring no single group can unilaterally impose new restrictions. When an agency tries to do exactly that, it not only harms Second Amendment freedoms, it erodes the principle of limited government overall. If you're concerned about where you personally stand regarding FRTs, it'll be wise for you to seek legal advice. Some interpret the most recent court decisions to mean that as long as you were or are a member of a gun rights organization like the National Association for Gun Rights, you might be protected under certain injunctions. Others say this applies to everyone. The legal picture is far from settled. The main takeaway is that folks should be cautious and stay current with reliable sources, given that an unfavorable court ruling can change the landscape overnight. Still, it's encouraging to see that the ATF has lost significant ground in courts, particularly after their bump stock debacle. The pattern we're seeing is that judges are no longer deferring automatically to agency decisions when it's clear they contradict plain statutory language. We as supporters of the Second Amendment should welcome these developments. They show that our constitutional framework has ways to correct governmental overreach, as long as people are willing to stand up and mount legal challenges. We know that if the courts hadn't intervened, the ATF might have used its broad interpretation of the machine gun definition to ban a host of devices never intended to be covered by that term. Of course, certain states align wholeheartedly with the ATF's perspective and may attempt to implement their own prohibitions. The Eastern District of New York, where rare breed is being sued, favors more firearms restrictions. This local environment is part of why rare breed must devote enormous resources just to keep afloat, even though a federal district in Texas ruled favorably on the same general issue. Conflicting decisions in different parts of the country show the importance of a final word from appellate courts, perhaps even the Supreme Court. A uniform ruling that forced reset triggers do not meet the machine gun definition would be a direct extension of the logic used in the bump stock ruling, bringing more consistency to a chaotic situation. We should also watch how the DOJ frames its arguments. Their fraud accusation implies rarebreed misled the public or otherwise engaged in deception by selling a product that had been deemed illegal. Yet many of us see that as an artificial legal stretch. If the ATF simply changes its mind about what's legal, does that automatically transform previous business practices into fraud? If such logic holds, any firearm accessory company could be targeted whenever the ATF decides to shift its regulations. That would be an unprecedented method of curtailing Second Amendment rights. Just bankrupt or imprison anyone who refuses to bend to contradictory policy statements. It's reassuring, at least, that other Pro-2A companies and advocacy groups are rallying to Rarebreed's defense. They recognize that if Rarebreed loses on these grounds, the government can employ the same tactics against others. This sense of unity across the firearms community is vital for resisting draconian measures. Court battles are expensive and public opinion matters. A grassroots network that keeps people informed and ready to respond financially or politically can be a formidable obstacle to agencies attempting to legislate via regulation. Even after these encouraging court decisions, the ATF remains steadfast in its desire to expand its regulatory power. People have flagged other accessories, like pistol braces or certain semi-automatic designs, as potential future targets. If there's one consistent pattern, it's that whenever the agency loses a ruling, it tries to reframe or reinterpret another category of firearms or parts to push boundaries again. This is why constant vigilance is crucial. Letting even one questionable redefinition slide can embolden further overreach. We have a civic duty to insist that any significant restriction on the right to bear arms be debated openly by our elected representatives. Word on the street is that both the Fifth Circuit Court of Appeals and the Second Circuit Court of Appeals will have more to say about forced reset triggers in the near future. If each circuit issues conflicting opinions, the Supreme Court could eventually step in again and settle the matter for good. That would be the logical endpoint of a legal drama that started when the ATF decided, without congressional mandate, to recategorize entire classes of firearm accessories. Whether the final verdict arrives this year, next year, or further down the road, we have to remain unified and proactive, supporting the lawsuits that challenge bureaucratic overreach and calling out every instance where an unelected body tries to regulate away our fundamental rights. No matter how these cases proceed, one thing is certain. The ATF's forced letters about FRTs, its contradictory website notices, and its continual effort to shift blame remind us that big government is not always transparent or benevolent. Each time the ATF loses a case or backtracks on a stance, we see evidence that activism and legal action can work. We also see how fragile our freedoms can be when placed in the hands of people who believe regulations can be twisted to suit political aims rather than to uphold constitutional principles. By paying attention, supporting Pro-2A organizations, and refusing to accept any redefinition of our rights without due legislative process, we ensure that the Second Amendment remains a living guarantee rather than a historical footnote. And that's all we have for you in this video. If it was helpful in any way, please help our channel grow by clicking on the like button, sharing this video with your friends, subscribing, and clicking on the bell icon for more of these videos. Thanks for watching,